Good afternoon, dear colleagues, and we start the first Q&A session in our session dedicated to artificial intelligence, something which has been discussed everywhere today. Within the framework of the plenary session, we set the tune of that discussion. We touched upon what is needed, that we have to come up with the legal capacity, with enforceability, whether artificial intelligence may be regarded as an inventor. And now we suggest that we continue this our discussion. Let me introduce to you the participants in our today's discussion. First of all, Andrei Niznamov, Managing Director, Artificial Intelligence Regulatory Center from Sber. Roman Dushkin, Science and Technology Director, Artificial Intelligence Agency. Dmitry Kozhemyakin, Senior Fellow from Tomsk State University. Igor Sobol, Head of Business Legal Support Center from Gazprom Bank. And today with us online is Alexey Amrosov, Lead Counsel Cognitive Process Service Europe and Global Business Service IBM. Also, we have the speaker from the previous session, Heli Pichlayama, Director of Patent Law, European Patent Office. Colleagues, I won't say more about the relevance of our today's agenda. I suggest that we start our discussion with a question of whether there is any future and prerequisites for delegating more authorities to the artificial intelligence, or digital identity versus intelligent machine. So I pass the floor to Andrei, who is working on the artificial intelligence. Can you share with us what approaches are you using, you are discussing there? Thank you so much. I hope that you can hear me well. Yep. Well, legal personality of robots and artificial intelligence has been on the table for 5 years, if I'm not mistaken. It started with the citation which occurred to the European Parliament back in 2016, when the European MPs actually adopted regulations saying that smart robots have to have the legal capacity. So there was a RoboLaw project in Europe, which started this issue and which proposed to delegate the digital identity to the robots, to the smart robots, to the intelligent machines, and hence we have a whole wave of debates and discussions whether robots or artificial intelligence can be similar to a man. From the legal standpoint, this is a new discussion, but from the standpoint of science fiction, this is an old and classical example, a very widespread case is that the very term of a robot can be originated back to 1920, when the daughter of the owner of the robot-making factory rushes into a room and shouts, "Why are you treating robots so poorly? Because they are just like us, the human beings." Immediately afterwards, everyone realized that amid the current context, it is totally unrealistic to assign legal personality and responsibility to the artificial intelligence or to smart or intelligent machines. There was a draft law in Russia presented for the consideration, which triggered a lot of discussions and can be reduced to one statement. why this is needed. This is totally unrealistic. This is what they said. But still, the discussion about that goes on. And every year I see 5 to 10 new publications on the AI legal personality being published abroad. This topic is not so popular, but in 2020 we see the reemergence of this topic when UNESCO actually started drafting the regulations on the ethics of the artificial intelligence. And a discussion was raised whether a legal personality of artificial intelligence may be incorporated into this ethics code. So let's wait and see, because another conference of UNESCO will be held next week. A more practice-based European concept is being prepared, convention, but in terms of the European Convention today, assigning certain rights or responsibilities to the artificial intelligence is totally not a priority. There are more practical response measures. For instance, look at the draft regulation on the artificial intelligence published by the European Commission yesterday. There is a big abstract topic, and there are more realistic problems which are of top priority. So this is a topic which we may speak and discuss today and tomorrow and in years' time, and always actually you'll find necessary food for such contemplation, for such discussion. You mentioned the draft convention, so when actually it would be endorsed? Until the end of this year, the Cabinet of Ministers of the European Union will hear the report on the results of the work of the Committee on the Artificial Intelligence, and I assume that actually the Convention on AI would be presented for the consideration in 2022, and after that it will have to be ratified, which probably will take more time. My question goes to Roman Dushkin with a progressive view on that issue. So, Roman, you have a dissenting opinion, I think. Well, let me add some controversy into our discussion. Well, why we people are delegating and assigning certain rights to each other, because we at least know that we are not zombies, that we have certain internal light emanating from us, that we can perceive the environment around us, sounds, colors, pain. These are the qualitative features of our consciousness. If we create an artificial agent which would be intelligent and which is not zombie and which will have the same perceptions, will we have to delegate to it the same rights and responsibilities, because actually it will feel pain, it will be anxious that it can be switched off, etc. We have a Digital Twins Lab. We are developing a project which in future would be aimed at reproducing digital twins for individuals or personalities who left a huge literary legacy. For instance, Pushkin is the author of many diaries, and processing all his literature works, actually we can recreate his digital twin as a literary agent which will collect information about the environment, and once you interact with this digital twin of Pushkin, he will know when you were born, he would write a poem to wish you happy birthday, and it would be kind of an inter-individual communication. But hence is my question. As long as it becomes more mature, we'll be able to switch it off once it gains more knowledge and more experience. Andrew, what do you think? Will we be entitled to switch it off? As a lawyer, am I saying that we, as lawyers, we do not care who we delegate rights or revoke those rights, withdraw those rights. So, if you want to... Have you ever seen a legal entity in reality? No one ever seen a legal entity in real life, but we actually delegated certain rights to that. So we can delegate those rights. We can assign certain rights to any entity. But I think that our presentations and our speakers will show totally different approaches to that issue. Well, if it is an artificial creature which would mimic Alexander Pushkin, if it perceives it switching off just like we perceive sleep, and we wake up and we're the same, we remember us being the same, so it won't be like that. It's not scary. But for instance, if this robot or this digital twin would feel a lot of pain for being switched off, actually it means that we'll have to assign certain rights to it. Because, for instance, the dogs which feel the pain, we delegate certain rights to them, at least there are animal rights. But I agree with you that this is about the regulatory assignment of certain rights and assigning a legal capacity, a legal personality to an entity. And it won't be regarded as an inborn or inept eligibility. So if we ever actually assign certain rights to an AI, it won't be done automatically. Alexander, what do you think about that? Can we use the legal entity concept to AI? Well, probably I will refer to the experience which we already have. Along with Andrei Neznamov, we co-authored a project, a primary concept of the artificial intelligence regulation in Russia, which was endorsed last year. We proceeded from the fact that in terms of regulation, we are pursuing a human-driven approach. It's very unlikely that in the foreseeable future our successors would see any change. It means that with reference to the rights which are being recognized by the Russian Constitution, by international laws, we are quite human-driven, human-centric. At least, actually, we are not in touch with any extraterrestrial creatures and animals, apart from human beings, in our opinion, according to our perception, are not as intelligent as to have equal rights with a human. What can be regarded as adequate is, again, looked through the human dignity. And it would be secondary to define the rights of technologies, the rights of animals, which are secondary to human beings. If we understand that any behavior is violating our human dignity, then this type of behavior is wrong, and it has to be restricted or somehow banned. Therefore, we criminalize and penalize the cruel attitude towards animals. And I do think that in the upcoming century, in the upcoming 100 years, we're going to pursue the same human-centric approach. And it is very unlikely that we give it up. Moreover, there are no technical and technological prerequisites. As to the contrary, it would be enough to have the current constructs when we regulate the behavior of a man, of a human being, whether it is compliant with its human dignity or not. This is how we are protecting some public interests. If certainly there is any public interest in limiting certain behavioral patterns, we're being guided by the same principles once we delegate the rights and responsibilities to some fictional entity. I would disagree with Andrew. Probably it's quite a positivistic approach that you may delegate certain authority at your discretion. For me, it's more important to grasp the point, to grasp the essence. We cannot recognize everything. Not every entity can be perceived as their legal personality. It can be done only if it meets the human interests. So once the human society was interested in facilitating trade and commerce, setting up a legal entity, we did that for that sake, not just because we could do that, and we did that. In the context of robots, certainly we can imagine that for a certain objective, a certain goal, such fictitious action can be possible. But this is not a subject matter for regulation or for a certain convention. It's rather subject matter for discussion. No one ever drew any arguments why the existing institutes are not enough. Anyone can set up a legal entity and assign any right to that, including the one of robots or intelligent machines. And actually, the responsibility would be triggered by the responsibility of the legal entities, because the founders of the legal entity, they bear the responsibility of what the legal entity is doing, including actually the actions done through its property, including robots. I think that this approach is most obvious, most apparent, and would remain unchanged. So it means that we don't have such technologies. Well, yes, the technological development actually prevents us from believing that any technology would equal a man. There is another opinion as far as technologies are evolving rapidly, and we see that it can be trained very rapidly. Don't we have to take a proactive approach and discuss these issues? Well, we can do that in the framework of a scientific discussion, but in terms of practical application, it would be too premature. Dmitry? Well, I think the legal personality, this is a purely utility concept. It's not that actually these entities would have the rights and these entities would be denied. So actually, once we need that for the civil society development, then we assign certain rights, attribute certain rights. If not, then we don't do that. Well, the slaves in ancient Rome were not so important for the civil society, and therefore no rights were attributed to them. Certainly, the owners, they took care of their health, especially mental health, but this is actually what we are doing to animals now. We do not regard them as legal personalities. The same is true of the artificial intelligence. The main question there is whether we have any utility purpose or utility target there. At the moment, there is no need for that. Whether it's going to emerge in future, I'm not sure, because actually when we delegate the legal personality to the certain being, then either we pursue the utility concept, what the artificial intelligence has created, or something else. At the moment, it is not clear whether actually the results of the work of the artificial intelligence should be assigned to a legal entity which owns an artificial intelligence or assigned to the AI in general. I think that this discussion is quite premature. It's quite interesting, and it was raised not only in the framework of the science fiction. Terry Pratchett has an excellent novel, Feet Made of Clay, where he raises a question whether golems have to have the legal personality. In my opinion, there is no need for that. And, well, actually, prior to the session, we discussed it that we don't have any such experience. You're absolutely right. You're absolutely right. In essence, Assigning legal personnel to anyone was a rare case in law, for instance. This was the case of slaves in ancient Rome, and it was the case of legal entities in the 19th century. So it means that international law science has no experience of tackling with such issues. At least no one being alive today had any experience in that. Igor, over to you.
Please tell us whether you have been considering this issue at your bank. At your legal department or anywhere. Yes, thank you. I will share my point of view. It's very close to what Dmitry has just said. Yes, indeed, there's no utility purpose because unlike items, intellectual property assets, by their nature, are not limited in space, and this quality can be assigned to an unlimited number of persons. So, this right creates the mode which is the core of regulatory framework in the sphere of intellectual property. Only law can can restrict anybody else than the owner to use and to commercialize the results of IP activities. And when Dmitry was saying that there's no utility precondition from the derived from the Latin word utility, which means usefulness, then when we talk about author who has to be rewarded for their work, what is the purpose that we need to implement to achieve with respect to AI? Or should somebody use something which is generated by AI, let's say part of the code, or some images, some musical works, who will be entitled to large claims in this respect? AI doesn't need such a right. So there's no answer to this question. Furthermore, attempts to assign something which does not create any semantic ideas or fully or cannot think as a human, this can entail certain risks. At the moment, so far we have heard about one funny case. This is called Naruto case. 5 or 6 years ago, the well-known, or the person who became known to owing to this case, the British photographer David Lees, was in the jungle. He was taking pictures of wildlife, and at a certain point in time, he left his camera aside and heard of what a tribe of gorillas approached him, and one of them made this selfie. And he published this photo. It then became quite popular, and then the NCO that protects animal rights started claiming that he wasn't the author of this image because the ape did it. He didn't press the button. So it caught David Slater quite a lot. Many years later, he was able to confirm the rights to his picture, but he became a real pauper by that time because judicial costs took all his money. So, with respect to IP property, we started raising the issue of legal standing and assigning the legal capacity. I don't think we have any real ground to do so. Furthermore, the US Patent Office back in 2019 published a survey, a questionnaire, asking what we should regulate rights to commercial results of IP activities. What would be the extent of human interference in creating such results, etc. At the end of 2020, they published a report based on this survey, and they came to a conclusion that the results generated by AI without any human involvement are not subject to legal protection by IP law based on the existing traditions in the US. But if there was a certain extent of human involvement in creating these results, then the results are subject to protection. And in this case, human would be having the rights. So we see that indeed, like many speakers have already said quite correctly, so many people have been arriving to the conclusion that at the moment the issue of legal capacity of AI individuals is too early to raise, if it is logical at all. Yes, we have colleagues online here. I would like to ask Ms. Heli Pikhlajama, the Director of the Legal Department of the European Patent Office. Heli, can you hear us? A little technical problem.
Добрый день, вы нас слышите?
Good afternoon, can you hear us?
Yes, I can hear you. Can you hear me?
Да, мы вас хорошо слышим и видим.
Yes, we can see you, we can hear you. Thank you very much for the presentation which you delivered in the previous session. You have already touched upon the issues of legal capacity and authorship to inventions. Could you please expand on your views in greater detail as part of this discussion?
Thank you very much. That is my pleasure. So certainly one needs to take into account that the question of inventorship is, of course, always distinct from the patentability of a certain invention. But when we are discussing the rights to an invention and the question of inventorship, of course, immediately, if we would start to think about the possibility to grant some rights to an AI system as the inventor, then we would immediately also need to then find methods how to assess the true inventor. Because of course, in that kind of inventions, it might be hardware, it might be software, it might be data that are involved, and who would be then the proper owner. So therefore, of course, it's better if we are not into that question at all from the outset, and certainly as long as we are not talking about legal personalities for AI systems or computer programs, that aspect is not there. I also heard from one of the previous ones the question of incentives. When we look at the fundamental principles of IP, of patent system especially, of course, it is a question of an incentive system. So to give incentive to an inventor to disclose the invention. And as we heard, what would be the incentive to a machine or to a machine owner? So what would be there? And we are also having, at least in Europe, we have all the legislations about employee inventors or university employers and the rewards that they are getting for their inventions. How would that be then in the future? One further aspect I would like to mention in this context is also the question of morality. Previous speakers were speaking about rights of animals. So rights of animals is also something which sometimes comes up in the patent system. And therefore, because we are talking about order public and morality, and we cannot patent inventions which would, the commercialization of which would go against order public and morality. So that would then also need to be taken into account, not only in the inventor question, but also in the question of sufficient disclosure. Would it be possible for everybody, and especially for the examiners in the patent granting institutions, to assess the question whether there is a violation of order public and morality? So with that, I wanted to come back to the previous part that we need to see the societal developments, and there I'm happy that you have also already seen the draft regulation on a European approach on artificial intelligence, which was published yesterday, and which would also give kind of definition and gives a lot of aspects, regulates a lot of aspects that can be taken into account in that. And of course, also keeping the human-centric approach in the whole issue. So there, with these thoughts, I would like to pass to the next speaker. Thank you very much for listening.
Thank you so much, Heli. And thirdly, we'd like to pass the floor to Alexey Ambrosov. Alexey, tell us, please. IBM is a very well-known company, one of the global leaders in terms of the artificial intelligence development, AI technologies. What's your personal opinion on that? As a company, what approaches you consider?
Нет, вас не слышно, надо, вероятно, включить.
Unmute your microphone, Beverly.
Слышно ли меня так?
Да, сейчас.
Can you hear me now? Yes, we can hear you very well.
Да, спасибо, спасибо. Рад присоединиться к вам.
Thank you so much. I'm happy to join you, although online.
Свой звук, поэтому, если позволите, я буду говорить в режиме с одной стороны, то есть как некое высказывание, как только закончу говорить,
I will
слушать, если будут вопросы.
just
Да, я тут интересно.
first speak and then we'll take any questions. This is with great pleasure that I listen to the previous speakers. The topic is clearly quite interesting and crucial, but in order to discuss the questions of legal personality and artificial intelligence, we have to define what an artificial intelligence is about. There are different cases and different cases of more advanced AI and less advanced AI. The artificial intelligence, which helps other people in decision-making, and actually there are AI systems which take decisions instead of human beings, and therefore the results of the discussion may be totally different. As many of us present at the panel are lawyers, I'd say that the case may be more complex than originally envisaged. Actually, there is a saying, ask two lawyers and you'll get three opinions. And also there is another saying that devil is in details. That means depending on the details, the decision would be different, or the outcome of the discussion would be different. Speaking about the IBM company, which is world-renowned leaders in AI and AI promotion, we use the following approach. AI for us as an complementary intelligence. AI, or artificial intelligence, remains the same, AI, but it can be deciphered not as artificial intelligence, but as augmented intelligence. Our approach may be more conservative than the one used by other companies or academics. We proceed from the fact that AI has not reached the level to gain legal personality or to be between a machine and a human being. Artificial intelligence, in our opinion, exists in order to help with decision-making, not to take decisions instead of a man. I understand that there are some situations when human may delegate decision-making to artificial intelligence, for instance, autonomous vehicles. But there are more complex
скажем так.
and
Но вот в том большом сегменте как бы корпоративного искусства
difficult situations, for instance. Once we speak about the commercial or corporate AI, not the consumer ones, we approach that situation from the standpoint that a man has to be able to control, to regulate what AI offers, and this is a man who takes the final decision. Certainly, a man would depend more and more on the offers and propositions made by AI or by software, but still, a man is the ultimate decision maker.
Поэтому в данной ситуации, опять же, может быть, несколько вольное сравнение, но если мы сравниваем, например, права и обязанности...
For instance, we compare rights and responsibilities of the minors, of the underaged people, and probably I'm creeping on the topic of responsibility, but as we know, misdemeanors, delinquent rights and responsibilities are limited a little bit. So there is a lower level of legal capacity or legal personality. And therefore, in our opinion, at least in the framework of the company, as far as I'm a lawyer for IBM company, I'm speaking on behalf of the company. And I know it's common opinion. I would say that it is too premature to speak about the legal personality of the AI. We are moving in that direction, but the approach should be about being quite cautious, making one step at a time. It won't happen overnight. We have to see what legal notices are needed, but we should not actually take a laissez-faire principle. Well, once you touch upon the topic of responsibility, do I understand you correctly that you say that this is too premature to delegate any authority to the artificial intelligence because AI, this is just kind of a tool? Well, my answer is positive. I will speak in my present capacity. Regarding AI being developed by IBM, this is a piece of a software. This is not just an autonomous vehicle or certain piece of a product. AI for IBM, this is a software made for business, which works in close cooperation with a human, and the human is the ultimate decision maker. I understand that, for instance, in case of autonomous vehicles, one-man vehicles, or in case of, God forbid, autonomous military vehicles, the situation may be totally different. That's a difficult question. There is a kind of a dilemma, and probably I don't have ready-made answers for your questions. Thank you so much. Really, that's a very difficult question, a tough question, which is on the table today. Colleagues, can you share your opinion? Responsibility of AI, is it too premature to discuss it, or as we see how the autonomous vehicles, taxis, and household appliances are evolving, the moment is opportune? Well, I would say that responsibility and legal personality are not closely connected. For instance, there was a dead-born, stillborn concept of legal entity, whereas the beneficiary of the legal entity's property could be arrested. There is a universal principle of legal responsibilities which can be stated as follow the money. So you have to find a beneficiary, and this is the beneficiary who has to be held accountable. Once we speak about AI responsibility, this is not a criminal or administrative realm, but rather a civil realm to indemnify the damage, recover the damage. So if we actually delegate certain rights and responsibilities to AI, we actually cannot indemnify any damage. So the artificial intelligence has no assets. The only way out, in my opinion, is to follow the money, to follow the beneficiary, to identify the entity, the personality, which gets benefits from AI activity or AI-based solutions. And we have to bring to justice the beneficiary. This is the rule which we can use in that case. If we believe to see some utility purpose in order to assign or attribute legal personality to the AI, it may trigger lots of discussions whether the beneficiary's responsibility be limited, meaning whether if we ever delegate legal personality to AI, still the responsibility would be borne and liability would be borne by the beneficiary. Well, I would agree with one reservation. Follow the money, that's quite relevant. One will speak about certain commercial use of the AI. There still might be situations when the automatic decision-making system is being used in some public agencies, so there is some public interest about that with no profit purpose. Well, but still, actually, this is the state which derives, which reaps the benefits in terms of cutting costs for the payroll, for instance. Well, who is to be responsible? Who is to be held accountable? Is it the public entity or public agency which has to be held accountable? It may not be very beneficial, for instance. If there was no one behind the decision, then there is less personal motivation to regulate this or that process, where the system would be fully automatic and would substitute a man and would take a decision regarding the fates of other people, who actually will be motivated to check that when this or that decision is taken automatically and no rights were infringed. I think that we have such a creeping risk. There would be a kind of an erosion, delusion, when we do not understand who is responsible for the decision taken. Not always it can be indemnified, compensated with money. I will not rule it out. For instance, there is an archaic concept of retribution, when the perception of equity, of justice, is generated by decent punishment for a certain perpetration. There are certain factors may impact that perception. When people were subjected to some unfair processes, would feel totally compensated and indemnified. Why this happens? What factors may contribute to that? Not always it can be measured in money. Well, but actually we have the shared responsibility principle, meaning that the victim would get some money compensation, and the state actually would try to eliminate the possibility of similar cases in future. For instance, it would be criminal responsibility once the damage is huge, or it would be administrative penalty if the crime is not so grave. Well, when certain individual actually receives a penalty and no one is responsible for that decision, the system may be motivated actually to issue more tickets. That's the problem which the law enforcement has already faced. Thank you. Roman, what do you think? What responsibility, what liability would be fair? In that sense, I would echo what colleagues have said. Really, it's too premature to speak about any responsibility before we assign legal personality to anyone. There is no responsibility without rights. And all the legal relations with artificial intelligence are being described by the Civil Code as of today, at the moment. But what I heard before, frankly speaking, I can somehow quote from our next future on certain cases which may cast doubt on these statements. I liked very much your item of utility, your statement of utility. So, legal personality should be connected to responsibility. And once the systems become fully autonomous, so they would belong as their items to someone, and the Civil Code would be enough. But once we have totally autonomous AI systems, AI agents, one of the definitions of the artificial intelligent entity is being autonomous. So the AI system should be fully autonomous, just like people. People do not belong to anyone. For instance, it may be an agent which would mimic some individual which passed away already. For instance, Daria. I can give you as a present an artificial individual which lives somewhere in the cloud of Amazon or Google or anywhere else, and it would write a poem to wish you a happy birthday. Who is the author of that verse, and why actually of that poem, and why we have to protect the IP rights of that artificial entity which lives somewhere in the cloud, just because there is a need for that entity to pay for its residence in the cloud. The same may be true for the autonomous vehicles. Once these vehicles become autonomous, once they perform some utility function, in the sense that they, for instance, carry some cargo of people, they would have certain needs. They need electricity, they have to be parked somewhere at night, and they have to be maintained. And for that, they have to earn money. Therefore, in blockchain, they will have a wallet, and the passengers or the forwarders will send money. And the same wallet would be used in order to set up an insurance fund, and all these entities would invest into that fund in order to be able to perform the commitments when some critical condition occurs and when they have to be responsible for their actions. This is one of the cases, one of the examples of using responsibility tool insurance fund that would be a consolidated one for all the autonomous vehicles. I see that you have a ready-made concept, and probably that was described in some books, but I'm not familiar with them yet. After that, I think that the artificial intelligence has to turn to a human and tell, can you relieve me of that burden? Colleagues, actually, we have more questions for discussion, but we are running out of time, as I was told. And there is another quite important question, the use of data. Data, that's the new petroleum. This is the driver for AI development, etc., etc. But there are some problems there, too, in terms of the legal regulation, for instance. We have a pilot mode, a pilot launched. For instance, the private data being regulated, and the organizations which are opting out of that system, they have to erase all this data. Andrew, I know that you took part in drafting the law, privacy law, and you are knowledgeable of that topic. What approaches can be used in order to boost the development of AI, to support that with the data, with no infringement to any rights, rights of organizations or people? Now we have two bills, draft laws. Actually, they translated into two laws. Actually, the law 223 on Sandbox, which regulate the use of data, and digital innovations law, which implies the sandbox to be created in the realm of data. The President instructed to create special access to data for the purposes of AI development. This is a paradigm in which we have to work. The draft law, which is being considered by the State Duma at the moment, on changing the regulation there of personal data, that's another stream. We suggested an amendment to offer privileged conditions and privileged access to the data for the AI developers. To some extent, this access would be similar to processing the data for the statistics purposes. In essence, it could be a solution, but certainly it would be just incomplete experience. We have an empirical experience of other countries, for instance, of the EU, and we have close bonds with the EU as far as we both are part of the Council of Europe. Well, actually, the regulation in EU goes ups and downs. So on the one hand, they have GDPR, then following some independent research, it became obvious that GDPR in the area of new technologies actually translates into more sophisticated approach for the data processing. Similarly, actually, it had to streamline the rules of the game, but something went wrong. Last December, a reform was offered in order to offer data for the developers. What would be Russia's stance in that respect? I think that we have to create necessary conditions to provide access to the data for the purposes of the AI, because AI will benefit all of us, especially Russia. And you don't have to infringe people's rights. There are lots of nuances which can be addressed, and the rights would be even more protected. Anonymity. Anonymity of the data, for instance, you take the private data and you make it anonymous, and you will never actually find the origin of that data. And the data, that's the fuel for the artificial intelligence. You don't have to ban anything. just provide access but limit the turnover of the data. And it will actually then be brought back to the economy and will bring us a lot of benefits. Igor, I have a final question about the data. What's your attitude towards this question?
So, I share views which are very close to Andrei's views. We have worked a lot on these projects of the draft regulations that Andrei mentioned, and I'm deeply convinced that it is critically important to create a balanced approach in our legal framework, which will help businessmen work with anonymized data, if you may, or other types of data which is not anonymous, data which is not infringing in any way on the rights of the data owner, does not infringe on the rights of a third-party database owners, and would at the same time enable these technologies to grow. Because AI, even in the existing form, what Andrei has just discussed, is the so-called narrow type AI. It, I believe, helps us to solve tasks in certain areas rather than solve these tasks for us. So this is a very significant leverage that helps us to develop economy, a very serious support. I think we need to create such legal framework, and we encourage everybody who's interested to join us in this respect. Colleagues, thank you very much, but unfortunately we'll have to wrap up this discussion because we have a very tight schedule. But I think it is quite obvious to all of us that this discussion must continue in course of other endeavors. I think that we need to continue these discussions at the Ministry of Economic Trade and Economic Development and Trade. Thank you very much, dear colleagues. I enjoyed listening to you. I enjoyed hearing your opinions, and I think we have certainly received food for further thoughts today.